Yeah, they told you to remove. It's a long story. Yo, what's good? We back with another Top TV. I'm here with Natalie Thomas, attorney Natalie Thomas. And she's a estate planning and family lawyer. A lot of y'all need to learn about estate planning and family lawyers and what they do, the ins and outs of everything that they do. And I'm glad you're here on the show today to give us some insight on all of that, because a lot of people don't know the ins and outs of what estate planning is, what a family lawyer is, and why they need you to help them.
Right. Yeah, I'm glad to be here because our firm does things a little bit differently. So our firm's called the Legal Joint, and I'm the attorney there. We just practice law a little bit differently. Most people think estate planning is planning for when you're dead or when you're dying. Reality is we should all be having some sort of estate plan in place, because you could walk off of a curb and get hit by a bus any day. So you might be in a hospital for a while, you might be laid up, you might not be able to get to your information, and you don't have anybody out there with a power of attorney. You don't have anything in place in terms of how to handle your digital assets, what to do, how do you get the bills paid, how do we keep our cell phone on, how do we keep the rent paid, what are we going to do? Most people don't have any plan when they're looking at incapacity. So, a lot of things on Instagram, TikTok, you're going to see all these like flashy things about how to make a trust and put all your stuff in a trust and do all these crazy things. But the reality of estate planning is it's a lot smaller. It's about how am I going to get through if I have some sort of emergency, some sort of unexpected situation, some sort of, car accident, whatever might take you out, right? Mm-hmm. How are we planning for that? Do you have some kind of plan for if you end up needing long-term care before you pass away, right? So do you have a plan in place? You might have heard the phrase Medicaid planning, meaning if you know you're not going to have money to pay for nursing home, how are you protecting your assets? Are you protecting your assets from Medicaid taking them if you have to go into a nursing home? A lot of people, older people, they don't think about this, and then they go into a nursing home, and as soon as they pass away, here goes Medicaid asking for the money. They want something out of the sale of the house, right? And all Granny had was the house, right? They paid for the house, they lived in the house all those years, and it might not be worth very much. But here comes Medicaid saying, well, we want $10, $11, $12, $13,000 because she was in the hospital or she was in a nursing home. But how you plan for that, you won't have that problem. You can have the assets transfer without Medicaid being able to get to them. So
you would be in full control.
Yeah, you'd be in full control. Well, in a way. So, there are a few different things you can do. Most people I talk to, they just need a basic estate plan. Some kind of will that says what to do with your stuff that would go through probate if anything was going to go through probate.
Yeah.
Some kind of healthcare power of attorney, so if something happens to you, the doctors know who to call and make a decision. Mm-hmm. The other thing most people need is a living will. Not everybody needs that. That's like a new age phrase for like a DNR. So within a living will, you'll say whether or not you want to be resuscitated. Do you want life-sustaining things like, do you want a ventilator? Do you want the things to breathe for you? Do you want artificial hydration, nutrition, these sort of things? So if you're terminally ill, how long do you want them to keep you alive or sustained with artificial means? So a living will lays out.
So all that goes into a living will?
All of that stuff is within the living will document. Now, you don't have to do all that. You can leave those decisions up to whoever you name as a healthcare power of attorney. And you can have a conversation. Like, I'll have a conversation with my husband. I have little kids. So I'm like, no, do everything. Mm-hmm. Do everything you can to keep me alive. Keep me alive. Yeah. Because you never know what's going to happen. And we're going to try everything. So that's right? But I talked to my husband about that. So I don't have a living will because I want all the treatment. Mm-hmm. And then my husband can make that decision if it gets to like a Terry Schiavo type thing. And there's like, doesn't look like I'm gonna make it, obviously, then they can make the decision.
How do you make that decision? You know, because that's a tough thing to decide. You know, even just thinking about it, living is kind of like, but we all got to do it.
You got to have those conversations. I think that's where you run into issues. You know, I have a friend whose brother passed away kind of unexpectedly, and her parents had to come together, and the family has to come together and make this decision. And if one person's ready and another person's not, it really makes it difficult on all of the family, right?
Yeah.
And so having those conversations is what's more important than maybe making decisions, right? So having the conversations so people know what you want when you're, you know, in a non-responsive state. And so, you know, how do you make that decision? Well, you got to talk with your healthcare providers, because I can't give anybody medical advice. Mm-hmm. So I can only give legal advice. And so if you're asking me what is artificial hydration, what is this, what does two doctors saying that?
What is artificial hydration?
So from what I understand it to be, my completely non-medical view of it, it's basically IVs for, you know, liquid IVs, the nutrition they might give you through an IV that would have calories or whatever else you needed in it.
To keep you alive.
To keep you alive, basically. So at some point you have to make the decision, like, do we want to, like, starve the person to death or, like, give them hydration and nutrition, right? So you got to make the decision when I'm in a terminal state and I have doctors saying you're not likely to recover, then do I tell them ahead of time, hey, I want you to pull all that off and just let me die at that point? Or do I want all the bells and whistles? And that's something you personally have to decide. Somebody has to make that decision. So either you can make it in a living will, or someone's going to have to make it. You're either your healthcare power of attorney person you appoint, or your next of kin, whoever the doctors are talking to. You take that off of them. You kind of take that.
That kind of eases the process up of everything.
Yeah, but it also upsets a lot of people, right? Like, so when you find out your mom signs some things like, I want to be out of here. She's like, I'm cool, just take me out. Yeah. That might cause you some kind of feelings, right?
Oh, yeah.
But having had that, you know, and some people don't have the conversation with their loved ones before they end up in that situation, then a living will's on file at the doctor's office, because you're going to put your healthcare power of attorney in living will. You go to my chart, it's usually in like a universal chart so people can see it. But, you know, you find out mom said, yeah, got it, right? I mean, then you're like, wait a minute, you didn't want to try to live? You know what I mean? So it can be hard when you're looking at the situation and
especially when you're the person that got to take, when they got you on that living will.
Yeah, you got to make, or if they put you as a healthcare power of attorney, you got to make that decision. That's, it can be a tough thing, but these are conversations that if you know someone's like, I don't want to be on, you know, a ventilator for 6 months and die slowly, I just take me out.
Just take me out of here.
Yeah, and so it's good to know what people feel. Everyone's going to have their own opinion. Yeah. You got to know. So those are three main.
Bury me in the ground, put me in the urn, things like that.
Yeah, so also we do talk a lot about that. So we provide people with the form. There's an Ohio State form that's just like disposition of bodily remains. So what do you want with your body? You want it cremated? You want this or that? If you have some sort of advanced planning at a funeral home, they will typically go through that form with you. Mm-hmm. If you don't, we give you the form and you can fill it out. It's not a complicated form, but that's a form that you can have on file somewhere with your paperwork. People would know what you want. I want to be turned into a tree, so you know, like I want to be buried naturally and then put under a tree, like to be a tree. But you know, you could be anything. Some people want to be like buried at sea. Some people want to be cremated.
Keep me embalmed.
Yeah, I want to be in a like
statue.
Taxidermy. So people have different opinions, but if you're having these conversations, you know in advance. You know, some people say I don't want a funeral, I just want a small celebration, whatever. These are conversations you need to be having. We kind of have those conversations with our clients, like you need to talk to your people about. You can tell me what you want all day. Yeah. But you need to talk to your people about it.
Your family is most important that you need to talk to.
Definitely. And so everybody should have a will, healthcare power of attorney, a living will if they want one. And then one thing we do different at our firm that I think a lot of firms aren't doing right now is we go through all your non-probate assets, and we have a worksheet you fill out. And
so what's a probate asset? Is a house, a car, stuff like that?
Yeah.
Right?
So
what's a non-probate asset?
So theoretically, everything could be a non-probate asset. Okay. But when I say non-probate asset, generally what I'm talking about is annuities, life insurance, investment accounts, bank accounts, anything where you can name a beneficiary. Okay. So if you have an account where you named a beneficiary, that would never go through probate court, ever. So our goal is to help everybody avoid probate completely. Don't tell them, because we're trying to put them out of business. But we're trying to help everybody avoid probate court. Like, I have a guy who recently called, and he's got, his mother passed away, and there was a property, and then there's like an insurance check, and like now they have to go open a probate estate just to cash a check, basically. Yeah. And I have another lady who
is probate expensive?
Oh, it's ridiculous. It's like $400 or $350 just to open the estate, depending on what kind of estate you're opening.
Mm-hmm.
So it can get very expensive. And then attorneys, like, we have to charge something for our time, and we charge a percentage of the value of the estate. So you got to pay for the filing fee. You got to pay the attorneys on back end some percentage. In Ohio,
So everybody get their cut.
Yeah, in Ohio, attorneys are allowed to take between 3 and 5% of the value of the estate.
It turns into a pie.
Yeah, basically. And so then you're looking at it. They're not simple forms. The probate court in Cuyahoga County is very, very friendly. Like they will help you.
Mm-hmm.
They're like one of the friendliest courts. But it's complicated. You got to do like these financial accountings. If you're selling the house, you got to get a realtor who's familiar with probate sales, because it's not the same as just like list it, sell it, right? You got to get approval from the court. You got to be keeping an inventory of all the expenses on the accounts and all. It's a lot, right?
It's a lot of work.
So you have non-probate assets. So I tell people all the time, you got a bank account, you got any kind of investment, whatever, all of that you're going to name a beneficiary. But I want you to write it down on this sheet of paper. I want you to put Wells Fargo, account number, blah, 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 and this is the person I named as my beneficiary. And then if you change that beneficiary, I want you to go in here and cross it out, write a new person and initial, right? So when you pass away and we have your list of finance, we have your list, your will, your health, all the things in the documents, right? Mm-hmm. Right with that is a list of all the accounts. So no one's going like, oh, I didn't know she even had this account, right?
Right.
Because if you don't tell anybody where your accounts are, how are they going to get the accounts, right?
Period.
Wells Fargo's not hunting down your beneficiary.
No, they trying to keep that bread.
They don't care if your people ever come for the money or not. They're happy to keep it, right? So we do include that one sheet, the non-probate asset sheet. And then the other thing I think we do that a lot of firms, I don't know any other firm locally who's doing this, but we go through what's called a digital asset list. So this is like access to your YouTube, access to your Instagram, access to your
So now we didn't
Google.
win digital.
Yeah, because people aren't thinking of this. But like, let's say your mom passed away, she has all these pictures on her phone, but you can't get into the phone. You can't get into her Verizon account. You can't get into her iCloud or whatever.
So this allows you to get access to all of this stuff.
So each different company, so Google, Samsung, Apple, they all have different processes. And we walk our clients through, you need to go through Google and click on these things and name a beneficiary, name a person who will be able to get into your account. I think they call it a legacy contact with Apple or Samsung. They each have different names. You name somebody, and then we have a worksheet, and you're going to write down Apple account, johnsmith@yahoo.com or johnsmith@icloud.com, and then I named Susie Smith to be my person who can get the stuff.
Wow, that's crazy.
So most people aren't thinking of that.
Because before we wasn't in that age, but now we in that age where we gotta have that because people got businesses online, things like that, like you were saying before.
Right. And when people pass away now, like okay, maybe even 20 years ago, as recent as like 20 years ago, when someone passed away, you go get the box of photos, you stick it down, and we all look through look at this picture, look at that, you put these up on the board with these.
It's not like that anymore.
No, nowadays you either going to have to go through their pictures and your pictures and everyone else's pictures and print some pictures or do a slideshow or something. But if you want to get pictures out of their files, their iCloud, their Google,
you gotta have a password, and it gotta be legal.
But see, the password might not even help you. What happens if you try to log in, you lock it up because you got the password wrong? Now it's locked up. Now you can't get into email or the iCloud or anything. You can't call up and be that person. So now we're locked out.
So Google, Yahoo, all these things, even if you locked out, they got access.
They will give you a side access, like it's like a side door into their stuff.
Hey, we're going to be back with attorney Natalie Thomas. Make sure y'all stay tuned. Estate planning and family lawyer. Yo, make sure you go check out Boss Botanicals. Get healthy, not high. 80% medicinal, 20% recreational. Breaking the chains for your health. So, you got a lot of dispensaries out here these days, and people think that it's all about smoking marijuana, but you got different products like CBD, hemp oil, stuff like that can help with your health journey. Not so much of about getting high all of the time. So these people right here, Boss Botanical, they have a plant-based online dispensary, and they also can help you start your own online dispensary. So make sure you tap in with Boss Botanicals. That's or at bossitup.biz. So that's BOSSITUP.biz. At Fee Family Law, we got Attorney Thomas on with us right now. Make sure y'all go check out that website. That's tljlawfirm.com. Make sure y'all go check that out right now. Estate planning and family law is important. We talking about it right now. We getting into it right now. This is the website. Make sure you go tap into the website. If you can click on it right now on the screen, click on it, go to it, check out some of the things that they got to offer, some of the services you can learn about. Because it's very important. You got to get your affairs in order. You know, people don't got their affairs in order. The Cleveland area, northeast Ohio, Cleveland area, financing available for as low as $100 a month. That's HVAC financing. WT Mechanicals is offering $100 a month. You know, you got to have a decent credit score. Your credit score can't be too jacked up, but if you got a 5, somewhere between a 550, 560, they can get that air, that central air that you want, or that full heating in your house that you need for the wintertime. So make sure you tap in with WTD Mechanicals. Click the link for the website, check them out, go and get you some AC, because it's hot right now and it's early in the summer. You know, it's just a couple days in the summer, maybe a week or two. So, you know, we got about 80 or to 90 more days, maybe, depending on how good we get summer. Yo, we back with estate planning. We back with estate planning lawyer Natalie Thomas, the legal joint. So what originally made you get into, what inspired you to start the legal joint and offer a flat fee?
Okay, so as I said, our firm does things a little bit differently. So for everything that we do in our firm, everything's one flat fee. So you know what you're going to pay up front. A lot of lawyers out here will charge you something up front and then hourly, right? So the bills could just, the sky's the limit, right?
Pile up on you.
Right, it will. And so some people think like, oh, I paid $3,000 to my family law lawyer, and then like 2 months later, like, oh my God, I paid $10,000 because they run through it. $3,000 at $300 an hour doesn't last you very long. That's not 10 hours, okay? We're not going to last very long. 10 hours.
Not that long.
10 hours. You've ever been to court? 10 hours can go by pretty quick. Prepping for court, talking to you, all this stuff. So,
because soon as they start talking, the money start counting.
Turn that billing on, right? Click the button. So, and believe you me, all these lawyers have plenty of tools. Every lawyer software has like how to start billing right away when they start talking to someone. But we don't do any hourly billing. It doesn't work for us because it's time consuming to keep track of it all and sending bills, and I don't like to chase people down for money. So what we do is everything's on a flat fee. So whatever it is, we have a pricing structure. We'll tell you what it is. I always offer people 3 options. No matter what your problem is, you're going to have an option where it's, we do the paperwork and you do it, but we make sure it's done professionally. We're going to write everything up for you. We're going to have you file it. Not on the court forms unless you have to use the court forms for certain things. But we're going to write the complaints out. We're going to write it all out. That's your first option. That's always the cheapest option. Then there's a middle option. We call the first option like a navigator. We'll help you navigate the process.
Yeah.
The second option is a co-pilot plan. We're going to be right by your side. We'll help you get the paperwork to the court. We'll help you make sure you got service. And we're going to give you coaching before you come to court. So if you got a hearing, I'm not going to go with you to the hearing, but before the hearing, I'm going to tell you what you need to say, what's going to happen, how you need to.
You're going to coach me through it.
I'm going to coach you through it. So I'm going to be your co-pilot. I'm going to be sitting next to you as you do the driving around. And then our third option is our full confidence package. That's where we're going to represent you. We're going to.
Y'all do all the work.
This is done for you. We're representing you like a regular lawyer, but it's a flat fee. So if I'm going to tell you it's X amount of dollars for your divorce, that's what it's going to be. Yeah. Right? Depending on if you have kids, don't have kids, dissolution, divorce, whatever. I
ain't gonna come in like I need another $5,000.
Right? No. So we do all of our full representation plans are going to go from when you first start with us all the way through your final pretrial. Then if I have to go to trial with you, we charge a different price if it's half a day trial or a full day trial. But we don't. All of that is laid out for you very clearly up front, so there's no surprise billing. I think it's unfair to people for the attorney to have basically an open check as long as they want to bill on your case, you know, and they'll just keep billing you. That's just, to me, I want more stability in my finances. People don't have just unlimited funds to be given to lawyers. So we do everything on a flat fee. All of our estate planning stuff also on a flat fee basis. You know, most of the people come to us for an estate planning. We can get, once they pay, we can get them done within about 2 weeks.
And I think that's a good thing. I think that's a great thing because at the end of the day, you know, like you say, people don't have a lot of finances just to dish out, you know, and this way you can actually get a bang for your buck, you know, and actually see your money.
Yeah, when I tell people I'm taking a risk that this is going to take me less hours than I'm quoting you for, right? So then it's an incentive to me to get your case settled. I'm not going to drag your divorce out for 2-3 years because I'm really underwater with this.
Yeah.
I'm motivated to get it done. My staff's motivated to get it done because they know the bottom line has to be met. We can't just be spending hours and hours and hours on a case. It helps me to really move the case along. It also helps if I end up spending way more time, you don't end up paying more money, right? And so part of it is we do really take into consideration when we're quoting numbers like who the other attorney is, what magistrate do we have, what county are we in, what's going on. Those things all kind of play into how we're going to handle, you know, how much time it's going to take us, and then we come up with the number. We do have some standard pricing, but we start at, but I mean, I have a list of attorneys I just don't take cases against because those aren't the type of people that that the flat fee's going to work with, right?
Right. How does the flat fee model change the way clients engage with legal services compared to traditional billing?
I think it really allows the client to feel more confident and feel more assured that they're going to get what they need. You know, they don't have to worry about in 2 months I might run out of money and I won't have this attorney anymore, right? Yeah. So I had a law firm in South Carolina for about 6 years when I lived in Charleston because I'm licensed here and in South Carolina. And I was a traditional law firm, did the hourly billing thing. All right, cool, you want a divorce, it's $5,000 up front, $10,000 up front, whatever I was charging based on the case and the assets and things. Okay, and then I'm going to bill you at $275 an hour, and when you get down below $1,500 in your retainer, I'm going to tell you need to send me another $1,500 to get you back up to your retainer. And no matter what happens, I'm going to keep sending you bills, right? And there were so many people who could pay maybe $1,500 or $1,000 or $3,000 up front, right? They borrowed money from their mom, they this and that. Then halfway through the case, they don't have any money left. And I have to get relief from the case, even though I want to help the person, but I can't work for free.
But it's like, you out of cash.
If you don't have the money, I can't keep working, right? So, and that's the thing different here. We do all flat fees. Everybody can start on a payment plan. So typically with family law cases, we need at least 50 to 80% up front before we file anything. So we don't mind if you start with $50. You have $50, you want to put $50 down, we'll open your case in our system, send you the intake form, you'll be in our system, you'll be one of our clients, and you could pay us $100 here, $100 there when we get to that.
We remember 50%. To call you back.
Right. Well, and if you don't pay, we don't do anything, right? Yeah. So until you get to that 50%, we're not going to file anything, we're not going to do anything, it's on you. Once you pay that 50%, then we start filing things, we can start doing things, and we'll get you on a payment plan.
Because all this stuff costs, you know?
Well, yeah, and it costs us money to run the firm, money to be there. I have staff, I got to pay them. They don't like it when I don't pay them, so turns out. But so basically, we got to have a payment plan in place, and I'll usually help people out. You know, whatever you can do. You get paid every other week. All right, cool. How about whatever day you get paid, we'll set you up to pay $50.
Yeah.
On those days, and when you get to that 50%, then we can help you out. If you're more of a rush, then go find some more money. Go borrow money.
Let me ask you this, Attorney Thomas. Can you explain the benefit of limited scope representation when clients might consider this an option?
Yes. Okay. So real quickly on the financing thing. So also we do offer a firm, which is like afterpay for people. So we try to make it affordable, but some people really don't need an attorney. I had a lady I talked to the other day. She has like a what they call a preliminary hearing, like the very first hearing on a family law case. I said, you don't need an attorney for that. Just go in there, tell them you're going to hire a lawyer. Don't pay me to come sit at the hearing because you don't need a lawyer yet. In this, the other person didn't have a lawyer. There wasn't anything going to be decided at the first hearing. I said, you don't need a lawyer for this first hearing. So, limited scope representation is where I say, okay, I'm going to represent you for one hearing. Or I have a lady whose attorney is retiring. She's got a hearing coming up, and so I need representation for this hearing, and my attorney's not going to come because he's out. You know, he's retiring. He's not coming.
Yeah, he's doing whatever he's doing.
The court let that attorney be relieved as the attorney, but wouldn't continue the hearing. So she's like, I'm in a pickle. I got to have somebody come with me. So she's paying me just to show up at the hearing, right? So some people know what they're doing. They kind of have a good idea how they want to handle their case. They might just want to hire someone for court coaching, right? They may just hire
you assistant.
Yeah, they'll hire me. I'll sit with them. I'll go through the strategy. Some people come to us and all they want, we call it a case clarity call. They come in, I'm like, look, let me look at the docket, let me look at what you got, let me look at what's going on. I'll tell you exactly what you need to file, where you need to file it, when you should file it by, and how much it might cost you to file it.
Walk you through it, step by step.
Yep, and I'll give you walk out of there with a strategy of how you want to attack the case, right?
Yeah.
So that limited scope is like, okay, or some people like have done it themselves the whole time.
Mm-hmm.
They've been going through it, they got all the way, now we're set for trial, and they just can't handle it anymore. They don't know how to get evidence in, they don't know how to call witnesses, they don't know what kind of questions they can ask. Those people call and say, hey, I can just go to trial with them. There's some people, you pay me, I'll prep and show up at trial. Right. So I have different, depending on what people need, we try to create access to justice in a way. So I've always felt like there's a gap. The lower your income, the more likely it is you're going to find some free service or low income service that will really kind of help you.
Yeah.
If you're really rich, it don't matter. They don't care. They'll just pay for a regular lawyer that charges the open ticket, right?
Yeah, here.
Then there's the people in the middle, all of us normal people in the middle, right?
Yeah.
We don't have thousands of dollars just to keep writing checks to lawyers, but we also can't get any of the free help, right? Because we're above some certain income threshold. So looking at those people kind of in that gap, there's a justice gap for those people accessing family law attorneys, estate planning attorneys. There's plenty of estate planning for, people who are, lower income or elderly, don't have any income, that sort of thing. But there's not a lot of help for the people in the middle. And so we're trying to create, that's what really inspired us.
Bridging that gap.
Yep, that's inspired us to create the Legal Joint. So I used to work at this really great place called Scranton Road Legal Clinic. And they do free brief advice for people in Cuyahoga County. So they're a great resource for people, and they're not income based. So they'll help pretty much anybody. But they don't represent anybody. They won't go to court for you. And I used to work for them. They're a great organization, and there's this gap, and I've always been, even when I had my law firm in South Carolina, I used to call it low bono work. Yeah. So it's not free, but you got to pay something.
Low bono, not pro bono, low bono.
Yeah, so we used to have that. So this is kind of like a little bit different because we're doing everything on a flat fee, but really we're trying to unbundle what people are charging people for and tell people up front, this is what's going to cost, this is what we're going to do, this is what we're not going to do,
right?
And this is what's going to cost you, and how do you want to pay for it? How are you going to come up with the funds? How do you plan to fund your legal costs, because it costs.
Let me ask you this question. What's a common misconception? What common misconceptions do people have about hiring an attorney, and how does your model address these misconceptions?
So I think one thing is a lot of people think attorneys are there to game them or not explain the process, right? To just do stuff in the smoke and mirrors and whatever. Yeah. That's not how we operate. I explain things. When you come to me and you want to know how to handle your case, I'm going to tell you why I'm doing something, what I'm doing, how I'm doing it, why I'm doing it. So how, when you leave my office, you're going to feel like, oh, I really understand.
You feel comfortable.
Yeah, you're going to feel like you know what's happening with your case. Mm-hmm. We're very open communication. We try to call our clients regularly. We try to really communicate with them. Before we have a court hearing, I have a schedule. I have a Calendly appointment. It's a court prep, hearing prep, and my clients get scheduled a week or two or whatever before when I have the hearing. So I'm on the phone with you. We're talking about it. Some lawyers, I think some people think hiring a lawyer is, they're gonna just it's gonna be so confusing and all this. And we're down to earth. We're just gonna explain it to you the way it is. If I think you need an attorney, I'm gonna tell you that. If I think you don't need an attorney, I'm gonna tell you that. If I think I'll tell you whether or not I think you're a good candidate for our first option, where we just kind of give you the navigation. We give you the GPS directions and you handle it.
Yeah.
But if you come in, you can't even get your conversation with me about your case, you probably need the co-pilot or the full competence, because you're not going to come through. If you can't have a conversation with me in a private room about something, how are you going to be in court with the other party?
You're not going to be.
Getting after you.
You're not going to be in court.
And how are you going to handle these conversations? So that's why we have tiers. But, I try to tell people, look, I don't think you're a great candidate to try to do this by yourself. Yeah. Or, there's some people, look, you're really smart. You got this. You seem organized. You seem like you're on the ball.
Let me walk you through it, help you out a little bit.
And those people are fine. But people, you don't have to be a, genius, but you got to be able to be calm, collected, really know what you're doing, and, really get yourself through that. And so we really we're trying to get people to a point where they can really understand why we're doing it, even if we're representing them full representation. And then the other thing with lawyers is a lot of people think they're going to go into some stuffy lawyer's office, meet with this lawyer, blah, blah, blah. Nah, we don't do that.
Drink coffee all day.
Yeah, look, you don't, we have an office in Independence, office in Cleveland Heights. We got places we can meet people, But generally speaking, aside from like when we meet you at court or meet you to sign papers if it's estate plan, we're not meeting with people because virtually that's how we save money. We don't need to spend time coming to meet with people or having you come into the office and all of this. Most of our conversations can be held on the phone or via Zoom. So that's something that's different about our firm. We're mostly virtual. I say that because I do meet people at court. I do meet. We have a Zoom meeting. I'll meet with you like before on the Zoom or whatever. But we're not gonna be. You don't have to come in and be all stuffy and come all the way down to meet us. You can take pictures of your documents and text them to us. Through. Yeah, we don't. You don't have to go find a scanner and all this crap. Just print it, take a picture, and send it back to us. Me.
Let me ask you this: What are essential documents? What are the essential documents involved in estate planning, and what roles do they play?
Okay, so we kind of covered this a little bit. I'll cover it a little more. Will. Everybody should have a will. Even if you got a trust, if you have whatever you have going on, everybody should have a will. The will is what's going to tell the probate court what to do with your stuff. Okay? So, assuming you have stuff still left that will go through probate court. Other essential documents are if you own a car, there's a form you can fill out at the DMV to transfer your car upon your death. So nobody has to go to probate court over your hoopty. 2, there's a transfer on death affidavit for your house. So you can do a transfer form for the house. Yeah. So that doesn't go to probate ever. Okay? Now, Medicaid can still get it that way, but we can talk about that in a minute. But the house never goes through probate if you do the transfer on death affidavit. You need to have a will. Everyone should have a healthcare power of attorney. This tells the doctors who to ask about questions about you. Like for me, it'd be my husband, right?
Yeah.
But if my husband weren't around, it'd be my sister who's a nurse, right? It should be someone who knows you, who's close by, who you've had the conversation with. But everyone should have a healthcare power of attorney. So a will, transfer on death for your house and your car, healthcare power of attorney, and then everybody should have a power of attorney. You don't have to give it to the person, but we used to be called what's called like a durable power of attorney, but this is a financial power of attorney where you're giving people the ability to like deal with your bank account.
Handle your business.
Yeah, so if you get hit by a car and you're unconscious, someone can go to the bank with the paperwork, right? Yeah. You don't have to give it to them right away, but once they have that paper, it's valid, right? And a copy is typically valid too. But, if you got a trusted person, a sibling, a spouse, a parent, a friend, whoever.
You can put it in the safe and say, hey, it's here.
Something happens to me, and everything in our firm comes in a pink folder. We give them a pink plastic folder.
As you can see.
Everything's pink. So we put it in a pink plastic folder. When that gets in that folder, you tell somebody it's in a cupboard by the fridge or whatever, or you put it in a fireproof box or whatever you do with it.
Yes.
Then when something happens to you, they can go retrieve what they need to do what they got to do.
Right.
Your healthcare power of attorney living will, you're going to give those to your doctor, and they're going to put it in the universal charts. So.
A lot of this stuff sounds congesting to people because you need, the power of attorney, you need the dynamics of the Medicaid, somebody for Medicaid, a lot of it can seem overwhelming when you're talking to somebody. How is it made simple?
So our firm takes a different approach. So once you come in and we look at your situation, and I'd say probably half the people that come in say, I need a trust. And I'm like, well, let me talk to you. And most of them don't need a trust. I would say, like, unless
you ain't got none.
Unless you got multiple businesses or multiple properties, or you have some other unique situation, like special needs trusts for special needs people, or if you need a Medicaid trust, which is where you're going to put yourself into an irrevocable trust, meaning you can't touch it anymore. So Medicaid can't get it. Or a revocable trust are those other ones. So depending if you got multiple businesses, multiple cars, multiple houses, lots of things, yeah, maybe. But you got one house, one car, and a bank account, look, we ain't making you a trust. You don't need to pay $3,000 for a trust.
It's not enough.
So, but we will get you a will. And we kind of just walk people through. So I have my initial consultation with everybody's free. I do a free 15-minute call. In that 15 minutes, I'll know whether you need a trust, a will, just a will, a basic estate package, what we need. And then from there, we'll be able to tell you, what to do. Generally, our basic estate package starts at $950 per person. And that's going to include your will, your healthcare power of attorney, living will if you want one, the digital assets, the non-probate assets, and then it's also going to include your power of attorney.
So the healthcare power of attorney is say, pull the plug, don't pull the plug.
Healthcare power of attorney says, something happens to me, ask my husband what to do.
Okay.
If I can't answer, ask my husband.
This person can answer for me.
Yeah.
What role does an executor play in the estate planning process, and how should one choose the right person for this role?
Okay, so that's the person that if you have to go to probate, you're nominating to be the person. Okay, so your executor of your estate is going to be the person who has to file everything with the court, with the probate court, or hire a lawyer to do it. They've got to show up to court. They've got to value all the assets, then tell the court what they did with the assets and what everything was worth and who they gave it to, right? And then the court has to approve it. That person has to be able to do these accountings, has to know what you have, all that stuff. My goal is that person never has to do anything, right? Because we're trying to avoid probate for everybody.
You're trying to avoid probate.
Avoid probate.
We don't want to pay probate.
We're not trying to pay the probate court. We're not trying to get lawyers, pay lawyers to do the probate.
We ain't hating on probate, but we just don't want to have to pay.
Right. And also just there's so many other ways to transfer your stuff. And so some people think they need a trust just to avoid probate. But in Ohio, we have transfer and death affidavits. We transfer for your car. You don't have to open a probate estate for basic stuff, right? So some of my older clients, I'll tell them, like, look, if you got valuable stuff at your house, like your spoon collection or whatever dumb thing people have, just give it to whoever you want to have it during your life.
Don't make it a big legal thing.
And tell people who you want to have what, right? So people aren't fighting over the spoons, right? But that stuff's not even really going to go through probate. That stuff, unless it's valued really high, just goes to whoever the executor wants to give it to, right? The executive is going to have to clean out your house, sell your car, do all the legwork with that.
They're the executor.
Yeah, even with an attorney, they're still going to have to do a bunch of legwork. So with the executor, you're nominating someone. That person can say, deuces, I ain't doing that. Like, no, sorry. You can name anybody, and they can be like, no, not doing it. So then the court would either go to an alternative executor.
Yeah, because what happens with that?
So you name somebody.
Like, I don't even want to have nothing to do with it.
Right. So you name somebody. If that person's like, nah, man.
Have you ever had somebody like that? Like, they was named the executor?
Oh, yeah. Happens all the time. People are like, I don't want to deal with that. It's a lot of work. I got stuff going on. Like, they don't want to deal with it. So you, in a will name an alternate. Yeah. And then if that person also doesn't want to do it,
it's like,
then the court will nominate
somebody.
And then the court will nominate someone. And if the court nominates someone, then the estate has to pay that someone to do the work.
Yeah.
Whereas if you do it for your mom or your family, like, you're not going to charge the estate hourly to do this.
I'm charging the estate.
So, I mean, you can. You always have the right to. But so basically, like, that's the problem. If people don't want to do it, they will appoint someone, but it will cost.
Let me ask you this. Can you explain, how do you handle cases that become more complex than initially anticipated while still adhering to your flat fee model?
Well, that's part of the gamble that I'm taking when I give you a flat fee. And that's why we set it up. I have a conversation. I know I'm asking who's the other attorney. If I really don't know how complicated a case is going to be, we're going to start with a strategy call. Yeah. And then after that strategy call.
That way you can figure out.
Then I'm going to spend 45 minutes an hour looking at the docket, looking at your files, looking at different things on Zoom or in person or on the phone. Usually those are on the phone. And then I'll know. So part of that's the gamble I'm taking. It happens all the time. Some things get more complicated. But then there's also ones that settle a lot faster than I ever expected them to. So ultimately, it evens out.
Have you ever had a case like that wasn't easy and clear and you had to do extra?
All the time.
Extra length.
Well, I have ones where, like, the other attorney turns out to be a dud, and, like, you end up, like, they're supposed to be right at the agreement, and they just don't because they're an idiot, and then you have to write up the agreement. They just don't do what they're supposed to. So, you never know what's going to happen in a family law case, especially. So you just hope. And I'm pretty efficient, though. Like, I'm not going to take BS. We're not going to fight about things. If the other attorney calls me, I had an attorney call me the other day talking about they wanted to talk about this lady. She'd been moved out of the house for a couple of months now. She's talking about she needs to come back and get her toiletries. I said, what toiletries? She's been gone for 3 months. We're not going to fight about toiletries, lady. Like, we're not doing this.
Like toiletries?
I said, so you need to tell your client.
Like bathroom stuff? No, we're not.
You need your shampoo. Like, go buy new shampoo. So, like, I'm not going to walk down that path with these other attorneys who want to just bill for no reason. Like, we're not going to have those conversations. I'm going to tell you, this is where we stand. What do you like about what we said? What don't you want? And let's come to an agreement.
Let's move forward.
Because everything, family law, almost all family laws, and as much as you think you hate that person, as much as you think, I'm never going to make an agreement with this guy, I cannot stand him, 99% of my cases are going to come to an agreement. Just because ultimately the question is, do you want, because remember, my fee agreement's going to go through the pretrial phase. If we're going to go to trial, you're going to owe me more money. Not a lot more, but you're going to owe me more money.
You're going to owe me some cash.
And the other attorney's billing the other guy hourly, probably, right? And then if you got a family law case with kids, you probably got a guardian. You got to pay that guy hourly, right? Yeah. And here we are. The bills are stacking up, and you're fighting over what? Every other weekend, an extra weekend, 2 weeks in the summer, toiletries. I mean, I had people who went, when I was in South Carolina, we had a week-long trial, and they're talking about, did you return the kid in the Nike shoes? Did you return the kid
really?
in the starter
Yeah,
jacket.
listen, y'all got to stop being petty. You know what I mean? When it comes to family like that.
Petty, just so petty. And the thing about family that always surprises me is like you like this person for at least a couple of minutes at some point.
Yeah.
Like I saw from some like strange situations, but like you like this person for a couple of minutes. You either had the moment where you got married and you like that person that much, now we're getting divorced, or you had the moment where you had a baby with this person. We all know how a baby's made, so you like that person for at least a couple of minutes.
So let's not go there.
But people just get petty. They just get so petty, and it's just unreasonable. And so it's when we get into complicated cases, I shut that down from the beginning. We ain't doing that, okay? You want to fight about toiletries? Listen, it's gonna cost you more to pay your attorney than it would be for you to go buy some new shampoo. So go buy some new shampoo.
Let me ask you this: what trends are you seeing in estate planning that clients need to be aware of?
So I actually just posted a blog about this yesterday. There's a lot of changes going on in estate planning. So, especially with this big fat bill they just passed, they're changing a bunch of different like taxes.
The big beautiful bill.
Yeah. So they've got also a lot of sunsets coming for some of the tax exemptions for estates and bigger estates, and likely they will keep some of those going.
Yeah.
Before it used to be like if you had an estate over like 25 million, it didn't matter. It might go down to about 7 million, right? So if you've got more than $7 million, you probably want to do trusts, some more planning, more gifting, more different things. So there are some trends in kind of the way the taxation is going to go. Ohio doesn't have like an estate tax, so we're going to change it. You're not looking at Ohio's taxes; it's federal taxes.
Yeah.
So some of the trends that I have been seeing is people who've been investing and making money on their investments, planning how you're taking those capital gains each year and dispersing them amongst other people. They're changing the amount. I think probably most people know the number like $15,000 is what you can give somebody as a gift untaxed. That number will likely go up to a higher number, meaning rich people could give their kids and grandkids more money each year.
$5,000, something like that.
Well, it used to be 15, and now it's probably going to go up maybe closer to 38 per year. So you'll be able to gift more money to more people.
Yeah.
Some of the trends I see just like in people, regular people, like not not multimillionaires, is just people making sure they have that living will and the healthcare power of attorney. I've seen a lot of doctors' offices really pushing it. When I worked with some of the seniors over at the Westerly, it's like an apartment building it's a HUD apartment building over in Westlake for elderly people, and just with getting that healthcare power of attorney, the doctors are saying you don't have one in place, put one in place, right?
Put one in place.
Right. Some people are like, well, I ain't got nobody, I got no family, I got no friends, like I don't know what's with those people, but some people had nobody to put down, so you don't make one. But I mean, a lot of the doctors are asking people before surgeries, do you have a living will, do you have a healthcare power of attorney? And I also see these trends with the digital assets. I mean, people dying and we can't get into their Instagram account, right?
Yeah.
Like let's say you got maybe, let's say, someone with 5 million followers, right, on Instagram, and they're monetizing the account, they're getting paid.
Big business.
Right, they're making money off their account, right? My husband's a caterer, he's going to do an event for the person's like a chef or a cookbook, whatever. They got 5 million followers selling cookbooks, right? Yeah. Well, if you're that person, but you don't have anybody who can get into your Instagram, if you die in a plane crash,
the money just sitting there.
Then the money just, where did it go?
It goes to Instagram.
Instagram's not going to be worrying about paying your heirs or what's the value of your Instagram account? When I go to probate your estate, what's the value of that account? And will that account make money without you? Can that account? And that's where some of the things I do with small business owners is we talk a little bit more about this. And a lot of my estate plans for small business owners include what I do what's called a business planning or business audit for them. Yeah. So, we're having an event actually in the end of August where we're going to have this kind of wealth planning plus business planning. Like, do you have your business set up right? Do you have a business plan? What happens if you get incapacitated and you're in a partnership with someone on a business and then you all of a sudden can't run the business? The other person's going to run the business? You got a third person you're going to add, like, okay, I know, then Johnny's going to step up.
Somebody got to step in, yeah.
And what's the plan? What happens if your business partner dies? Do you get the business or are you going to split it with their children, right? Well, how is this going to work? So you need to have information on that. And there's really all that planning. So August 24th, we're having an event. It'll be over in on Chagrin over in
Make sure y'all come
Shaker. I'll post the link below. But basically, it's going to be an event. We're going to have, it's free for the kids. The adults, you got to pay for all your knowledge you're about to get. But we got an event right for it. There's going to be a game truck. There'll be food. There'll be stuff for the kids to do while you learn. You get knowledge.
We're talking that legal jargon.
Yep, and we got vendors there, and we're gonna talk about business. We got my business, my friend Keisha and I we're gonna talk about business. Mm-hmm. She's gonna talk about getting it set up right, making sure you got it all set up right. Business coaching, how are you setting up, how are you doing it, and then also we're gonna talk about your estate plan, your business estate plan. What do you got in place? Do you need a trust? Who's a good candidate for a trust? And really getting into that's another trend really.
It's important, people.
Another trend is these small business owners. There's more and more small business owners out here. People going out on their own, doing it on their own with no plan for what happens if incapacity or death occurs. They don't have a plan.
It's important, y'all. This is important. This, Natalie is bringing us something that's very important to our face, right to our face, so that we can understand where we going, and because you're not going to live forever. You know what I mean? You would like to live forever, but you're not going to live forever. So it's just like you can live forever through paperwork.
Yeah, and you can plan your legacy, what you want it to look like, especially as a small business owner. You want to have in place what happens to your business. You don't want to work your whole life. I'm not about hustling. We're not about hustling. I know you like hustle, but listen, it's about thriving and doing it right. So your business makes you money, not you work in
Aside from the hustle, let's do your
I want you to work
front office or back office, what we say.
Yeah. I want you to work on your business, not in your business, right?
Yeah.
So I want you to grow your business in a way that you have people working for you, working on the business, and you're growing that business. And then we're going to talk about how we're going to protect the value of that business, because eventually you can't just keep doing all the work all the time, right?
It gets tired.
I don't intend to just always be the lawyer all the time, right? Eventually there'll be more lawyers. There'll be more people taking over stuff, right? So when you're looking at growing your business, that's part of your legacy. Because if you can grow a business that makes enough money, then your kids and grandkids can inherit whatever it is. But if that business needs you to live, needs you to survive,
it's over with.
It's over with. You get hit by a bus, and there goes your business right out the door.
It's over with. And it could have been making millions of dollars.
And the next day, and that's where you might be the face or the brand of the business, but unless you got it set up in a way that you're going to be successful, and that's what we're going to be talking about August 24th, the small businesses and the legacies. People who are like, look, I got a little bit of money here, we got a house, or this, that, whatever. Okay.
How do we keep this going after I go?
How do you keep it going, and how do we avoid probate? How do we avoid taxes? How do we avoid our children having to pay capital gains tax? Which I had a lady a couple weeks ago, didn't believe me.
Yeah.
I told her, like, if you inherit something, you don't pay capital gains, right? Like, so if y'all have ever heard of capital gains, you see this is what they're talking about. You know those TikToks? They're like, my dad gave my brother a house, he paid all these taxes. My dad put a house for me in a trust, and I didn't pay any taxes, right? If you give someone, so some people think, like, I'm just gonna add Johnny to my deed.
Yeah.
No, don't do that in life. Because now Johnny's going to have to pay tax from the
Johnny going to be responsible.
Johnny's going to pay all his taxes.
He's going to be mad at you while you roll into your grave.
Do not just add Johnny to the deed.
Johnny going to be cussing you out.
Right, because he's going to owe all this capital gains tax.
Yeah,
so
man.
if you don't want him to pay the capital gains tax, then you send it to him through the transfer on death, as you would, or through a trust if you've got a couple houses or whatever.
Send it through a trust.
Yeah, and then a trust really is where you get to write the rules. This game, you write the rules. It's a blank slate. You can write whatever. I mean, assuming they're not illegal rules, or there's also something called, a big lawyer word, called the rule against perpetuities, meaning like you can't have it like never go to anybody. So like there has to be like, it will go to Susie, but if Susie dies before me, it would go to Johnny. And if Johnny and Susie both die before me, it would go to whatever, whoever the hell else. And then at the end, and if none of those people are alive, I give it to the dog foundation or whatever. You had to have a catch-all clause at the end, but you write the rules on a trust.
A lot of work. Hey, we're going to come back with attorney Natalie Thomas, estate planning lawyer, family and estate planning lawyer, the legal joint. Make sure you go to tljlawfirm.com.
why don't you come over here? I need to ask you something quickly, my dear. Why do you always settle for something less? You know that, baby, you deserving the best. Yeah, yeah. Go take a look up in the mirror. You gotta see a little clearer. Who's that woman looking right back? When she's a beauty queen, bad, bad. You ain't nobody's number two. These men, they should be fighting over you. No second guessing what I'm saying. Baby, you can take this to the bank and make it sweet. It's time to listen to yourself right now. Make it sweet. Don't even listen to these guys right now. Make it sweet. Let's trash your baby deep inside right now. Make it sweet. So go and see what you can find right now. Don't you know you're not just some other girl? There's no one like you anywhere in the world. You have a strength like nothing I've ever seen. You're like a woman ripped right out of my dreams. Yeah, yeah. Go take a look up in the mirror. You gotta see a little.
It get like that. Oh, we're back with another Top TV. I'm here with estate planning and family lawyer Natalie Thomas, Natalie Thomas, the legal joint. Make sure y'all go to tljlawfirms.com if you got any type of family business you want to handle. She can get you in the right. She can get you going in the right direction. Today we talking about all of the things that can get you going in that direction. Let me ask you this, Natalie. How do you stay current on legal trends and changes in law that may affect your practice areas?
Yes. Okay. So there's kind of a funny story I'll tell you. So when I was first practicing law, it was like, maybe I was like 4 years in or something. I had my law firm in South Carolina, and a client called in and was like, "Hey, is so and so available?" And the secretary's like, "Oh no, she's at a continuing education thing all day." And the person's like, she doesn't know. She still got to go to school. And it was like, no. So we have to do so many hours of continuing education every year.
Yeah.
And I'm a member.
To stay up on top of because laws change.
Yeah. And I'm a member of the Cleveland Metropolitan Bar Association, and they offer like a pass. You can go as many CLEs as you want. So I always go to more than I have to because I just like to go learn
stay
things.
On top of your game.
Stay on top of different things. So I'd stay on top of it that way. I also, we talk with other estate planning lawyers. I'm in some listservs where you got a question, you're like, what about this? What about this weird situation? Anyone else dealt with this? And some attorney will be like, I know a person, or I've done that, or whatever. So, collaborating with other attorneys is super important because, and things that change. So a lot, like federal court, I do very limited bankruptcy. But in federal court, they have brown bag lunches where they want you to come in, the judges talk to you about trends. Same thing with family court or juvenile court or
so they have
probate
brown
court.
bag lunches like summer camp, huh?
Yeah, you got to bring your own lunch. You can listen to the judge tell you what her new rules are. Basically, that's what that is. So all the courts will have that, where they have new rules are coming out, new ways they're going to handle things, different things they're going to change, and they're going to contact, we'll have a little people, they call members of the bar, so lawyers, they'll let us know what's the changes. And so then you just kind of keep track. Also, just like, we got to watch trends with legislation, things that pass through the Senate, through the House, through the local Senate and House, and then also through case law, right? So keeping up when you think you know the law, just double check the case law, make sure there's not been another case that changed it. I have malpractice insurance, like attorneys know I don't have to have it, but we have malpractice insurance, and our insurance sends out a summary every, I guess, quarterly or twice a year or something. They send us a summary of all the new case law that might affect attorneys and discipline. And then I've got some other friends that are like, every year they do like a CLE where they go through any random law changes that they go through. So, you always able to stay up on game because they always putting things in place where you can learn new laws. Yep, and you just got to keep your ear to the ground. That's the difference between some attorneys. Some attorneys are like, I know what I'm doing, and they don't. They get in court and lose everything for something. Because you got to stay on top of things. And there's some areas of law that I know really well because I've done a lot of it. I've done a lot of paternity cases. I've done a lot of juvenile court cases. Done a lot of child support cases. So I know those areas of law really, really well. I mean, you know other areas of law well too, but like those ones, I could run circles around some attorneys when it comes to paternity and custody, especially when you got 2, 3 parents involved. Like if there's like an alleged father or like a father who's the biological, but they're not the person who's the father legally because the legal father signed the birth certificate or something like that. So when you got, I mean, there's some areas of law that some attorneys just never learn.
Let me ask you this: Do you had to pass the bar too?
Yeah, I passed 2 bars.
Oh, really?
So I took the Ohio bar in 2010, and then 6 months later, I took the South Carolina bar in 2011.
Okay.
So yeah, you got to take a bar exam. So you got to go through law school, and then you got to take a bar exam. They made it easy for the new kids because now they can take a universal bar exam.
Yeah.
They don't have to take multiple like the rest of us had to.
Let me ask you this: how often should someone update their estate plan, and what triggers might necessitate a review?
Okay, so my basic rule is every 5 years you should dust them off and check them out.
Yeah.
Things that would trigger it: divorce, had a baby, someone that you listed as an heir dies, like when your child dies, someone who's in your documents dies. If a spouse dies, marriage, divorce. If you buy a house, if you obtain, if you obtain a bunch of properties, if you start a business, if you close a business, if you win the lottery, any major life change that is something that would alter your financial or personal choices.
You need to update it.
Yeah, especially people who go through divorce or separate, whatever. Look, you don't want to find out that you forgot to take your ex off of the beneficiary for your life insurance, right?
Man, they getting the cut.
Right. So, or like, oh, you forgot about that Fidelity account. You only had $3,000 in it, but it still went to your ex. You don't want that. Right. So after people get divorced, I tell them they need to do a whole financial audit. You need to talk to a financial person, a retirement person, and get your estate plan in order because you need to make sure, one, whatever you were planning for your retirement might change. And I don't do that, but I have people refer people to it. How did that change? Okay, you got divorced. How does that change your business? Okay, you got divorced. How does that change who you give stuff to?
Yeah.
Does your will still say everything goes to your husband?
Right.
If you didn't change that, so I say bottom line every 5 years. That's
every 5 years you got to update it. What tax implications should individuals be aware of when planning their estate?
So, generally speaking, things that you get through an inheritance you don't pay tax on unless you're over like this huge threshold. So the normal common man in Cleveland, like we're pretty low cost of living area. Houses aren't worth a ton. I mean, our houses are, a really expensive house here is worth $500,000 or $600,000, right?
Yeah.
And like a hovel in LA costs $500,000, right?
Yeah.
So
a hole in the wall.
Most of the tax implications are people with like $7 million or more. Okay, if you don't have $7 million, you're not worrying about the taxes. Some of the things to consider is don't ever add anybody to your deed during your lifetime. Now, if you're married, you can add a spouse. A joint tenancy is what it's called, where 2 people own it, and whoever lives longer wins, right? That's a joint tenancy. You join. Neither one of you owns the whole or half of it, right? So you all own it, and whoever lives longer, they win, right? They win the property. So you can have a joint tenancy with pretty much anybody, but don't go adding people to joint tenancies that aren't your spouse after you've already bought the house, because it'll cause tax implications. And the easiest way to explain it is, if you sell your house tomorrow, you bought it for $100, right? Yeah. Let's say $100,000. You bought a house for $100,000. You sell it for $200,000. You can take a certain percentage of that extra $100,000 and put it into an account to buy another house. Okay. The other percentage is going to be taxed as a capital gain. Okay. So if you add me to your deed during your lifetime, you pass away and I sell the house, I get your basis. It's called basis. I get your amount you had when you bought it, that 100. You die and you give it to me as an inheritance, I get the stepped up basis to what it was the date of your death. So I don't pay taxes on that $100,000 gain on the house.
Wow.
But if you add someone during your lifetime, they're going to pay all that tax and that gain. And that's where they're going to be pissed.
Because I was going to ask you that, what steps should someone take if they want to disinherit a family member?
We get that all the time. You'd be surprised how many people want to disinherit people.
Get you out of here.
It's surprising. It really is. So it's not that many steps. You write a will and you can put in there. So it used to be that you had to like give them $1. Like you had to put like, and I give $1 to Susie and $1 to Johnny, and the rest of everything goes to Jessica or whatever, right? But now you can just in Ohio just put in the will. I specifically disinherit blah 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 these people.
Yeah,
right? I do not want them to. Under no
nothing.
circumstances should they get anything from my estate.
They get nothing.
They get nothing. And then you also put a clause in there that says anyone who challenges my will gets nothing. I mean,
So if you campaigning for him, you won't get nothing. Get him out of here too.
yeah, if you're challenging the will, you get nothing. So you can put a contest clause.
Oh,
in.
so you like, oh no, I'm supposed to get this, I'm supposed to get that.
Yeah, if you're like, I don't like what I got, and you challenge it, now you get nothing. So
Oh my God.
take what you got. Get what they say in
Take what
kindergarten.
you got.
Get what you get and don't have a fit. It's kindergarten, okay? So, but you can people disinherit people all the time. I mean, there's some people who skip generations. They specifically disinherit their children and give it to their grandkids or whatever.
Yeah.
I mean, that's allowed. And theoretically, I'm not a tax expert, but theoretically, you're not paying taxes on inheritance. Pretty much anything that's inherited, you're not going to pay taxes on.
So, get them out of here. You
can write people right out of your
listen.
inheritance, like right out.
Listen, take what somebody giving you and get out of there. Don't be greedy.
Right. When I will say, okay, there's a difference between contesting the will and then filing an adversarial proceeding, which is like a lawsuit within an estate. If you think the person was influenced or what have you, unduly influenced, or, like all of a sudden they're leaving everything to the neighbor who was like, and you think it's suspicious, that's different than just challenging the will. Yeah. But if you come and say, like, look, I don't think
he should
they had dementia. They had a dementia diagnosis before they filled out this will. This shouldn't be, right? Or the person who wrote that will gets everything. What's up with that, right? I'm not. And by the way, if your lawyer ever suggests they're going to get something out of your estate, they're not allowed to do that. Tell them that's not happening.
Really?
No, we're not allowed to profit from our clients' estates ever.
Y'all able to get the money.
We're allowed to take up
paid.
3 to 5%. That's all we're allowed to take.
Yeah.
Depending on the estate. Even if I thought you had the best house ever and I wanted to buy your house, I cannot buy your house from your estate if I'm your estate attorney. So there's all these rules.
That's against the law?
Yeah, it's against the rules of conduct for lawyers. But you can challenge, like saying, I don't think the person was with it. I mean, we do have a lot of people, and this is what I will say for people. Be planning. If dementia or Alzheimer's runs in your family, get on this now, okay? Because once you get a dementia diagnosis or Alzheimer's diagnosis, you can't really sign papers anymore. Like, you can't be, because no one can know if you're lucid or not, like if you're in your right mind. So if these are things in your family, or people typically end up in nursing homes, be planning for this Medicaid planning to get you a nursing home. Nursing homes cost like $9,000 a month, and if you need memory care, it's like $16,000 a month. If you don't have that, and you don't want to like sell your house and just hand it over to a nursing home, you got to do that 5 years.
That's all your cheese.
And you got to do that 5 years before you end up in a nursing home. So there's a 5 year, they call it a look back period. So if you owned an asset in the last 5 years, they can claw that back and make you pay Medicaid with it, right? So we don't want that. Once you get dementia, you can't sign your own will. You can't write out a power of attorney. So if mom starts slipping and she doesn't have an estate plan in order, and all of a sudden you're trying to go to the bank and talk with the bank, and they're like, no, you need a power of attorney. You get a power of attorney, but mom's already got dementia. It's not valid. Anything you do, then someone will come back and challenge it. Say she wasn't with it when she signed the power of attorney. I don't want that for people. Yeah. If you've got memory issues or dementia or whatever in your family, be on this stuff early, because
be on there early, y'all.
You're gonna end up putting yourself in a bind.
Let me ask you this, Natalie. How can charitable giving be incorporated into an estate plan, and what benefits does it provide?
So, once you've passed away, the charitable giving is only charity at that point. Like in real life, when you're alive, you give money to charity, you can write it off your taxes, right? Yeah. And every estate has to file a final tax return. So the year you died, so if you died in 24, in 25 you got to file your final tax return. Yeah. And the estate has to open a bank account and do all these other things too. That's why probate's complicated, because you're gonna have to go open a bank account for them and do all this accounting and file a tax return and all this. Yeah. But you can give money through your will or any other means. You can name a charity as a person on as a beneficiary or something on your documents. However, talk with that charity first. I think a lot of people don't think this one through. This is probably not, I don't know, what most people don't have this problem, but people try to give houses, and like I heard an attorney talking at a continuing education one time with the Cleveland Clinic was like so belaguered because they were donated an airplane.
Oh.
There's someone's estate.
Oh, really?
And they had all this trouble, and this lawyer who's getting paid so much money.
They was upset.
She just was like, oh, we're in the charitable giving department, and they tried to give us an airplane, and it was just so much trouble. But all that to say, people try to give houses or cars or whatever to a charity. You have to make sure that charity wants that thing, because just once they get it, can they use it? Are they going to have to sell it?
How much are they pay for it?
What are they going to have to do with it? Like, does it need fixed up? Like, now they're responsible for the taxes. So you got to find out, does the charity want what you're trying to give them? If it's cash, I'm sure they'll take it.
Yeah, they'll take that.
But if you're trying to give them a house or a car or some other thing or equipment, I don't know, you got to ask these people, do you want this? Like, I want to put you. And then some places like Salvation Army and some other places have like standard clauses they want in your will and how it's worded for how to make those donations. So you just need to make sure you're talking. I mean, and we know who to call at some of these places, but if it's some smaller charity or your church or something, make sure you're talking with them and saying, hey, if I put this in my will, will you guys be able to handle that?
Get your business in order, people. And that's why we on the show today, for people to get their family business in order, their estates in order, because like Natalie says, Attorney Thomas says, you have to make sure that these things are going in the right place, so it won't be nothing won't be mixed up. It won't be a mix-up. You know what I mean? People will be able to really it'll be a smooth transition. It won't be a lot of confusion and family arguing and bickering over the estates and stuff like that.
Yeah, and I mean, honestly, like, that's one thing our firm, we try to help our clients understand. Like, let's rip the Band-Aid off. Let's have a conversation. Talk with your people while you're alive. You don't have to get everybody together and then it turns into a brawl. No, but you can pull people aside and say, hey, this is what my will says, so don't be surprised. Or, this is what I'm doing with this, so don't be mad if it turns out this way or that. And that really sets people up to have less fighting on the back end. They already know what's going to happen. And having people understand that makes a lot more sense. And that's partly why we're doing like our event in August. Yeah. It's actually called No More Excuses. It's called Legacy Unlocked. We're gonna
more excuses.
You don't have an excuse for not having an estate plan. People make it affordable. It's really not that difficult. And then we're going to teach people, how do you have these conversations? What are you doing with your business? How are you planning for a legacy? Having money is not a legacy. Yeah. Having cash in the bank, not a legacy.
Especially if you can't keep it going.
Right, and if you can't keep it going, you don't have it going to the right place. The bank doesn't know who to give it to. It gets stuck around. If you have a bank account and you don't have a will and you haven't named anybody, on like as a death beneficiary on your bank account, they have to go pay $450 sometimes just to open a stupid bank account, estate, just to do the bank account, right?
Crazy.
So you don't want that, So if you want a legacy, you've got to plan a legacy, not plan to have just some money while you're alive, right? We need to plan a legacy so that your grandchildren and children and grandchildren, whoever, the neighbor's kids, whatever your plan is, those people can really thrive. And you're not just, working your behind off your whole life, hustling, making money just for what, right?
You give it to the state.
For what? To give it to Medicaid because you can't afford a nursing home.
Yeah. What is your vision for the future for the legal joint, and how do you plan to expand or evolve your services?
So part of what is the legal joint is we're trying to bring things together. We're trying to be that connection, that joint between, let's say, shared custody, that's joint custody, right? We're trying to be that joint between the older generation in their estate and this younger generation in how we plan in our estates, that joint between you and your children, people that are in their 30s to 50s with children and little kids. How are you planning for those kids? I mean, there's a lot of people out there with no plan. Let's say both parents go on vacation and they're on a Malaysian flight, disappeared, right? Yeah. What's happening with these kids, right? Do you have a plan in place? Really, we're trying to bring that joint together. So our vision is to grow the firm, continue to create this access to justice for people who don't already have it, affordable services that people can really get into, have more attorneys doing more work for more people, and really growing in a way that we're a mostly virtual firm. We have access to what people need at a price they can afford. That's straightforward, upfront. They know what they're going to be paying for, and there's no surprises in the back end. But also they're set up so there's no surprises when they die or when they get incapacitated. They're really just set up to be successful.
That's dope. You know what I mean? You need that. You need that. You need that. Go to tljlawfirm.com. Read about it. Learn about some things. Give Natalie a call. You know, I want to thank you for coming on the show and giving us some insight on all that you do.
Yeah.
And definitely, you know, keep on helping people with what they got going on, because it's important that we get these affairs in order, you know.
Yeah, thank you for having me. I mean, I wish we could get the word, you know, I want to get the word out. Like, it's really not difficult. Get a will in place. No excuse. There's literally no more excuses for why somebody does not have a will in 2025. It's not complicated. And look, the world is not predictable lately. You don't know what's going to happen tomorrow, and we don't know what's going to happen. And you got to have a plan. You got to have a plan, or it's really going to go kind of haywire. I mean, it won't matter to you if you die, but your people going to be pissed. Yeah. And they don't want to deal with that. Mm-hmm. Especially, and you know what, if you become incapacitated, I mean, I wish more people understood how much of estate planning is about before death. And really having a plan.
It's important, y'all. From what I'm hearing today, from what we've covered today, is important to make sure you take care of, get all of your ducks in a row. You know what I mean? So make sure y'all stay tuned to these top TVs like this, informational top TVs like this with your main man, Hollywood Chuck. Thank you for coming out, Attorney Thomas. Until next time, y'all.
Yep.